very carefully. And I learned early on, and I wish I could remember who it was, some great sage lawyer. It was probably someone like Joe Cheshire or one of my heroes in the law. The answer to that question is cross-examination is not your closing argument. Meaning sometimes defense counsel and even plaintiff's counsel, they want to argue points with officers and other witnesses. This applies in rec cases as much as it does criminal cases. They want to argue their case in cross-examination. Argue your case during closing. That's when you're supposed to argue your case. I personally think it's better to not ask questions on cross-examination, period. And then you say, wait, well, don't you need to effectively cross-examine? Like, well, yeah, and, not but, and make it minimal. Get to your point. Don't beat around the bush. Now, there are times there's some witnesses that are just going all over the place and you kind of have to rein them in a little bit and you start big picture and work your way down. My cross-examination of officers, if I'm concerned about them not answering the question, and there's some officers that are, I swear, are trained not to answer your direct question. You'll ask them what time of day it is and they'll tell you the time of day and then they'll add in some additional facts you didn't ask for to try to get some information in. And that irritates me. I also don't like looping of the question, meaning they repeat it and repeat themselves several times, thinking that the jury or the finder of fact appreciates this perpetual unanswered question, unasked questions, and non-responsive questions. So I do approach it very carefully. I know generally maybe 2 or 3 points that I want to make. If I have to narrow somebody in, I will start big picture and get them to agree to some big points. Another thing I think with any witness is just being polite, being professional. This idea of just ramming it down their throat may be good TV drama. Every once in a while, you go toe-to-toe with an officer, and I have found that involves more ego on both sides, or maybe unfounded machismo, if you will, or unnecessary. I think there should be a level of politeness and professionalism, and you can express a disdain for an answer or a way something was handled in a polite, professional manner. I also don't ever ask what I don't already know. That's kind of the classic law school answer to that question. With regard to technical things, I use their training materials and protocols as the gold standard, and then I hold up the gold standard and I say, and follow these. Or which ones did you follow? And so I look at reports, training manuals. I rely on the publications that they are used and trained on to learn how to become law officers. So you can be polite, you can be respectful, but you're also relentless in your preparation and knowing what you're talking about. So how do you approach cross-examination of a police officer? Very carefully.